Good morning, everybody. Just 5 minutes. I think the technician there is busy with. Good morning once more. I think we can start even if it's not already there. You will find us along the way. We have got apologies from 3 members, Honorable Zagute, Honorable Mute, and Honorable Kaba. And the first thing on our agenda is briefing by SAPS-CI on its input into the General Intelligence Law Amendment Bill, GILAB. Can I hand over to our generals? Over to you, General.
Thank you very much, Chair. Honorable Chair and honorable members, the South African Police Service Crime Intelligence Management have been invited to a meeting of the Ad hoc Committee on the General Intelligence Laws Amendment Bill to give input into the General Intelligence Laws Amendment Bill. First and foremost, please allow me, Chair, to tender an apology for the National Commissioner of the South African.
We can't hear this from the side.
I don't know if I'm audible now. It's on here. Like this. Chair, if I'm to start from the beginning, I wanted to say that, Honorable Chair and honorable members, the South African Police Service Crime Intelligence Management have been invited to a meeting of the Ad hoc Committee on the General Intelligence Laws Amendment Bill to give input into the General Intelligence Law Amendment Bill. First and foremost, Chair, please allow me to tender an apology on behalf of the National Commissioner of the South African Police Service, General Fanny Masemola. The National Commissioner is attending other prior commitments and could not join us today to lead the team. Chair and honorable members, as you are all aware, crime intelligence mandate is to collect, analyze, and disseminate information in an effort to anticipate, prevent, and monitor criminal activities in the country. CI also provides technical support for investigations and crime investigation operations. And lastly, it contributes to the neutralization of crime by gathering, collating, and analyzing intelligence information that leads to an actionable policing activity. This gives effect to the constitutional mandate of the South African Police Service as set out in Section 205, subsection 3 of the Constitution. However, the effectiveness of intelligence depends on the coordination of all intelligence agencies, and for this reason, all the intelligence agencies are required to work together and to operate within a legal framework where their respective roles and responsibilities are clearly defined. The coordination between the different agencies strengthens the efforts of government to promote a safe and secure environment for all. It is against this background that the South African Police Service welcomes the opportunity to take part in the deliberations on the Intelligence Laws Amendment Bill and believes that the legislation proposals will strengthen the coordination of intelligence for the benefit of the Republic and all who live in it. Thank you, Chair. Now, together with me, Chair, I'm accompanied by the Divisional Commissioner responsible for crime intelligence, which is Lieutenant General Kumalo, supported by Major General Lushaba. I'm also accompanied by Divisional Commissioner Legal Service, Lieutenant General Kamani, and is supported by Major General Van Rooyen. General Kumalo will take us through the presentation, Chair. Oh, in fact, it is our legal service, Major General Van Rooyen, Chair. My apology.
Good morning, Honourable Chair and Honourable Members. The purpose of our presentation today is to specifically focus on aspects relating to crime intelligence insofar as the bill is concerned. As you can see, the first few slides, or can we just go one back, please, to slide 3. The South African Police Service welcomes and supports the General Intelligence Laws Amendment Bill. We believe that the proposals contained in the bill will strengthen the capabilities of our intelligence structures. It will enhance coordination and cooperation between such structures, and it will promote the skills required to gather intelligence in an effective manner and to analyze the intelligence in a coordinated manner to assist and protect the interest of a country. The bill has also been identified by crime intelligence as a matter to improve the governance and regulatory framework of crime intelligence, as it has been identified previously as a weakness for crime intelligence. Honourable Chair, with your permission, the first 2 slides only deals with technical matters that we observed when we perused the bill. It is not meant to be criticism, but it's just matters that we identified from a technical point of view. First of all, the bill proposes the insertion of a definition of cybersecurity. As many of you will be aware, the Cybercrimes Act came into operation 2 years ago, some of the provisions, but initially the Cybercrimes Act also consisted of a cybersecurity bill. So the cybersecurity bill was delayed, or the bill was split into two, and the Department of Justice will be promoting the cyber security bill as well. So our submission in this regard is just to take note of the fact that there are other legislation dealing with cyber security specifically, also in the development phase. Then, Chair, another technicality that we've identified is the syntax in the two definitions pertaining to domestic intelligence vis-a-vis foreign intelligence. And we have included the definitions there. Insofar as domestic intelligence is concerned, it is defined as intelligence on any internal threat or opportunity or potential opportunity or threat or potential threat to national security. Insofar as foreign intelligence is concerned, it is defined as intelligence on any external threat or potential threat and opportunity or potential opportunity to national security. As I said, these are just technical matters that we have observed, and we wanted to highlight them to the committee. Furthermore, Chair, provision is made for the definition of security competence test. However, in the proposed clause 3B of the bill, the reference is made to security assessment or security competence assessment. In other words, the discrepancy between the words competence test vis-a-vis competence assessment should also just be clarified to avoid any potential confusion in this regard. Then, Chair, if I may move on to the specific legislation that is proposed to be amended by the bill. First of all, the National Strategic Intelligence Act. The South African Police Service is in agreement with the proposals relating to the definitions of national intelligence structure as well as security competence test. We also support the supply of national security intelligence to NICOC by crime intelligence. Furthermore, we are in agreement with the proposal to include the activities of the Communications Center insofar as crime intelligence is concerned, and we fully support the proposed amendment of Section 2, capital A of the Act, which specifically provides for the compulsory vetting as opposed to the current discretionary vetting of certain persons, including persons employed by or who is an applicant to be appointed in an organ of state. These proposals are also aligned to the proposals contained in the South African Police Service Amendment Bill. And we believe they will greatly assist to enhance the security competence testing in the intelligence sphere. Insofar as the Intelligence Services Oversight Act is concerned, the police is in agreement with the amendments relating to the accountability of crime intelligence and also the efforts to enhance cooperation amongst the national security structures on counterintelligence functions and activities. Honourable Chair, insofar as the Intelligence Services Act is concerned, we support the proposed inclusion of a definition of a former member and also amendments on the establishment of the National Academy on Intelligence. However, we do have concerns insofar as other intelligence structures are concerned, insofar as the Command and Control and the Advisory Council of the Academy, to ensure that there is relevancy of other intelligence structures provided for. Then, Chair, finally, just to inform the committee that the South African Police Service Amendment Bill is planned to be introduced in Parliament during the next parliamentary year. The draft bill inter alia aims to promote professionalism in the South African Police Service. Provision is made in the bill for the insertion of a new chapter specifically dealing with police service intelligence in the furtherance of Section 210 of the Constitution, and the chapter aims to address matters such as the structure of a division, coordination with other intelligence agencies, and matters relating to the security vetting of employees. Chair, that is our presentation. Thank you.
Thank you very much. Can I open up to members for clarifications and questions? Honorable Kolabanat.
Yeah, just one area for clarification. Could you spell out to me what you believe to be, let's say, the definition of an applicant to an organ of state? The reason I'm asking is we saw originally in the original version the rather bizarre inclusion that the heads of NGOs and churches must be vetted. Obviously, that was removed as unconstitutional, so that's not in this final bill, but I'm a bit nervous it's being snuck back in through the back door. So please just tell me what you see as a definition for that term. Thank you.
Honorable Hendricks.
Thank you very much, Honorable Chair. Honorable Chair, I was very interested to hear that it's very important for all intelligence agencies to work together. So that means if they don't work together, they can't carry out their mandate. It means that South African Police Services, crime intelligence can't carry out their mandate. So they are hampered if there is, if everyone is not working together. So if we take the July unrest, and you know that I've been very engaged with the President on this and the failure of the intelligence services, and one would expect, the Chair, that the crime intelligence would have been at the forefront to prevent what was happening. So we have to lay 100% of the blame on them because they are our front line. If our front line is not working, then the country is not in safe hands, and then you get a Minister of Defense and a Minister of Intelligence misleading the President, and that's why he fired them and removed them. So if our national, our South African Police Services crime intelligence, I want to know if this legislation strengthens them, that if they're let down by their colleagues, and I met most of them when we did a budget at the beginning of this parliament, let them down because the rivalry, the competition. And also we know that in crime intelligence, we still have remnants of apartheid operatives working there. We know that Mossad is very active with them. And I'll tell you why I say that. I went to the American embassy, invited for lunch, and the Mossad guys were there, and they tell us that they provide South African police crime intelligence with information about drugs, because I come from the Cape Flats, so they felt that that's a nice topic of discussion. So my concern is, don't they have any proposals or further proposals on the general intelligence laws to make them more effective? Why must they depend on other agencies? They must be able to stand on their own feet. And then lastly, it is a responsibility of South African Police Services crime intelligence to provide personal safety. Personal safety in our homes, personal safety when we go to the supermarkets, and personal safety when we're in the parks, and personal safety in the streets. The police depend on them. They need to prevent these things, and they're not doing it. For 30 years in a democracy, they're not doing it. The apartheid government did it more effectively than they do. So what is wrong? Is it because they depend on all intelligence agencies and that everyone must work together? That's a pipe dream, Honourable Chair. Thank you very much.
I thought, Honorable Hendricks, you would come with a suggestion yourself on what what do you think they need to insert to strengthen them?
Honourable
But
Chair, I've asked my legal counsel in the party to come up with clauses to strengthen it, but we would like to hear it from them. They're in the field. What does legal people do? South Africa must be run by lawmakers, not by legal eagles.
Okay, any other members? Honorable Stebe?
Thank you, Chair. On the last page, SAPS Amendment Bill, I'm interested in that and seeing that you provision is made for the insertion of a new chapter to address police service intelligence in the furtherance of Section 210 of the Constitution. So, as I've got it, you will have a chapter on crime intelligence and how they're going to work. I just want to know, with the new General Law Amendment Bill that we're busy with, and you said you're going to produce that in 2024, that bill. Will it, is it envisaged that you will include what came out of the General Intelligence Law Amendment Bill? Will you include that in that chapter of your bill? Is there time, or are you done with your bill, or is it ready for to bring it to Parliament, or will there be time for you to change that? Thank you.
Thank you very much. Follow-up, Honorable Kola-Barnard.
Thanks. Yeah, it just struck me with the vetting that is referred to there, considering the backlogs. What would you see yourselves undertaking versus what the State Security Agency undertakes? I know there are backlogs in both areas, so it can be a massive issue, and we know from the delays in the vetting, for example, of the board of the SABC, that it did cause huge delays. So I'm a bit wary that this might put an additional burden on yourselves. So just fill me in there of your ability to do the job. Thank you.
Thank you very much. A follow-up again from Honorable Stebe.
Thank you, Chair. I see that on page 6, where you're in agreement of proposals relating to the definition of national intelligence structure and security competence test. Now, can you just elaborate on the competency test? Because that's a new phrase that I'm not familiar with, because it's not in other legislation. That specific phrase, that as far as I know, I might be wrong. Yeah, I'll stop there. Thank you, Chair.
Competency, security competency test and security competency assessments. Yeah, maybe the difference between the two. Any other member?
Thank you, Chair, and honorable members. The very first question in relation to the definition will actually request that it be responded to by our legal service. And interchangeably, they will respond in between the role that should be played by the operational, which means it will be the role that is played by divisional commissioner responsible for CI. And with regards to all legal matters, our legal department will respond to those questions. Legal, over to you.
Thank you, General. Honourable Kola-Barnard, yes, there's no definition provided for in the Act on an applicant. It is our submission that it will be, for example, if a person has been recommended for appointment, in other words, not the long list, so that we will not be able to security vet or conduct and security assessment of every person who applies, because the number of people will be too many. But it is our submission that it should be the recommended person for appointment. In other words, to ensure that that person is complies with the security vetting before he is appointed.
Okay.
Clarity, if I may. When you say the definition provides for an applicant, you believe it to be an applicant, is this for a job
Yeah.
within the SAPS-CI defence,
Yes.
what?
With-
So you're not envisaging it to involve anyone who's applying to do a service for some government?
That
Okay.
as
So that's
well.
what you believe, but there's no
Yes.
definition.
There's
So
no definition.
that's what we hope it means. We
Yes.
don't know. So that has to be clarified.
Yes.
Thank you very much for that input.
Honourable Hendricks, you pointed out the fact that intelligence agencies should work together. That's critical. There's no doubt that none of us can work in isolation, despite the fact that we have different mandates pertaining to the gathering and analysis of intelligence. We are dependent on each other to also share that intelligence to ensure that its effectiveness can be enhanced. Because if we sit with intelligence that may be useful to other intelligence agencies, its value diminishes as a result of the fact that we are not sharing it. I think in respect of the proposals contained in the bill, the establishment of a communication centre will go a long way to enhance coordination. I think the strengthening of the inspecting general will also assist to enhance coordination, to ensure that we learn from our mistakes in the past, and that going forward we will be in a better position to share and coordinate intelligence and to ensure that the intelligence structures are in a position to ensure the safety of the country. Honourable Statement, that is correct. The Sturban, I apologise. Sturban, okay. Sturban. I apologise, I'm renaming you. Okay. With all due respect, most men are, so you do fit. The plan is for a new chapter. At this stage, we are looking at Chapter 6C, capital C, to be inserted in the South African Police Service Bill. As you will know, from a legislative point of view, there's a lot of processes that have to be complied with before a bill is actually introduced in Parliament. And you will appreciate that this process, especially if you consider the amendment of the South African Police Service Act, is not a small feat. It's a mammoth task. So we are working very closely with the Civilian Secretariat of the Police Service. They are responsible to draft and advise the Minister, but in view of the fact that it cuts across operational matters that specifically impacts on the South African Police Service, we are working very closely with them. So the idea is for a whole new chapter to be inserted, keeping in mind also that the South African Police Service Act was enacted in 1995. So it predates the Section 220 of the Constitution, and also a lot of other developments pertaining to security vetting, proposals to strengthen the capability of the police as set out in the National Development Plan, the panel of experts on July unrest, the Farlam Commission, to name a few. All of those findings and recommendations impacted on the development of the amendment bill. So that is just something to take into account. As I've indicated, the plan is to introduce it in 2024 after a lot of work and consultation has been done with various sectors, including public participation when the SAPS amendment bill was published for public comments and so forth. So we believe that everything is ready for the bill to now be introduced in Parliament so that we can proceed with the enhancement of the South African Police Service. Then your question relating to the assessment of a security competence test, there's a definition included in the bill for a security competence test, and if you allow me, I will read it. It means the administering of vetting investigation to determine the security competence of a person or institution, and if such person or institution is suitable to access classified information or critical infrastructure of a state, or is viewed as vulnerable to blackmail, undue influence or manipulation, or security compromises, or is a person or institution of national security interest. So that is the definition. In a very basic, or to provide a very basic explanation, currently we're talking about security vetting, but the plan is to change the wording and the principles, or to enhance the principles by incorporating it into security competence test. So security vetting will be removed and it will be replaced with a security competence test. And Chair, as I pointed out initially, the discrepancy of a definition referring to a test and the provision, the amendment to Section 2, capital A, referring to it as an assessment. That is part of our submission, just the discrepancy, so that we shouldn't be in a position where we confuse people as if it refers to different matters. Whether it's a test or whether it's assessment, we believe the terminology should be consistently used in the bill. Thank you, Chair.
Honorable Stebe, it's a follow-up on.
Yeah, it's a follow-up.
Okay.
Thank you for the explanation. The only thing that I see is that it's no use you're going to put in your new 6C that you put in there competency test, and the rest of the security service of the GILAB make provision for security competency assessment. Because the assessment, I think, envisages the same thing as that you've got in your test. It's semantics. It's a test against assessment. So it might be that assessment is more favorable for SSA, for DI, while you prefer tests. So maybe you must just keep that in mind to see afterwards if that is, if you're in correlation with the rest. Thank you.
Chair, I apologize. I forgot to answer that part of your question, sir. Of course, this bill is already in Parliament, so any amendments or proposed amendments to the South African Police Service Amendment Act will have to be aligned with this legislation. We were not aware of this intelligence bill when we finalized the South African Police Service Amendment Bill. But, for example, the references to security vetting that remained in the SAPS Act will have to be aligned to the new terminology. And just to make sure that we do not confuse matters by referring to the same aspect but in different terminology.
You are still on the floor.
Just on the proposed section 6 that you talked of, I would have expected that part of that's relating to crime intelligence would also came by the JSCI, and I think we would appreciate it if we can also have a look at it and maybe give an input into that. We've never seen this. First time I hear about it. I've never seen it. You say it's already in Parliament, but we haven't seen it in this committee, and I think that's a pity. Thank you.
Sir, just to clarify, the SAPS Amendment Bill is not yet in Parliament. The plan is to introduce it 2024.
Yeah, that was my exact question, because if we can work perhaps with a draft of the one, because they're envisaging us including an entire chapter from their one, I think we need to work. It's no good us passing a bill that has to be amended in 6 months' time. Absolutely can't happen. So I think we need to liaise about that specific chapter as we go along. So we would need a copy, I think, of the proposal of the full chapter.
I can see Honorable Stebe.
Yeah,
It's an open meeting. I see why the two of you are bending on these issues. It means you know exactly what it means. Okay?
Chair, it's not to be difficult, and but I think the JSCI is the committee that does the oversight. And if we don't know what's happening there, how could we correlate it with our oversight function in terms of the legislation, Act 40? That's the only reason why I think we should have insight into that in this committee. Thank you. In the JECI. Thank you.
What I understand the two members to be saying is that you can legally smuggle what you want into this bill because it's already here. Unlike waiting to put that chapter in the SAPS Act, which might take 5 years, as GILAB did. So they are advising you to legally smuggle that chapter in here. You were still on the floor.
Chair, I take note of the opportunity and the invitation to get involved in legal smuggling. Thank you, sir.
My general?
Chair, those our responses, sir. Unless there's any clarity that is being sought to respond to.
Honorable Hendricks?
The buck stops with the person that gave his apology, that is the National Commissioner. Does the legislation put his name in the box? If any one of the dozen agencies mess up, can he then be held accountable? And shouldn't that be very strong in the legislation that we do have different agencies all working together or supposed to work together, but we know they don't? I haven't heard any one of you say, no, we do work together. I haven't been given peace of mind that we do work together. So I assume that I remain unchallenged in my view, the view from the streets, that you guys don't work together. So I want to know, where does the buck stop and does the legislation provide for that?
Well, without being their advocate, I think there are structures, the net joints, the whatever, where they are all this, they meet in there, there's NICOC, there's whatever in there. So, net joints, so without being their attorney, I think that's where they meet, they share the information there. It might be maybe if one or two agencies don't use that information, but the sharing, I would say, the structures are there where they share. But over to you, General.
General,
don't contradict me.
Thanks, Chair, and greetings to you and the honorable members. Chair, in terms of the Oversight Act as it stands, I can't remember the specific section. I think it should be around 4 or 5 sections, somewhere there. The National Commissioner of the South African Police Service remains responsible for financial and administrative functions. The Divisional Commissioner of the CI remains responsible for operational matters. However, the National Commissioner, in terms of the Constitution, remains the accounting officer of the service. So the buck still stops with him. any misdeed that can be done by the divisional head of CI and or whoever as a member of the service, the buck still stop with him. For now, it's a him, or refer to him as such. Thanks, Chairperson.
And Chair,
I think maybe the question was, when I said I'm being your advocate, I understood the question to be saying that the buck must stop with the National Commissioner, even for the other services, which can be possible. When you are talking about SAPS only. Yes. Yeah, but it's not possible for the National Commissioner to be responsible for something that was not done by SSA also. But General, you are still on the floor.
yes, Chair, and honorable members, I just wanted to say that we have defense intelligence that does not involve the South African Police Service at all, including the National Commissioner. We also have the state security. Each and every agent within the Constitution, they have their own respective roles as prescribed by the Constitution. There's no way the National Commissioner of the South African Police Service can take responsibility for all other agencies. That is my response.
Does it mean the buck stops with you, Chairman?
Okay, they are still on the floor. My other general?
Thank you, Honorable Chair, Honorable Members. Maybe to add on the response, yes, indeed, as the Deputy Commissioner is putting it, but there are mechanisms that are in place to ensure the coordination of activities within the intelligence community, and that is why on our comments and inputs we appreciate the fact that there is the legal structure that is in the bill that talks to the national intelligence structure, which is inclusive of all the intelligence agencies. Previously, we used to call ourselves just intelligence community, as if it's a casual relationship. But hence then, that's why we appreciate that. Also, the fact that if you look at the objectives of the bill, there are a lot of activities where we are grouped together in terms of the bill. You talk of National Communications Center, you talk of the National Intelligence Academy, where we will, over and above cooperating and coordinating our operational activities, there are also other areas where there will be cooperation. The bill will also strengthen the mechanisms that are already in place, as I've indicated. The NAT joints leg of intelligence coordination is co-chaired by SAPS as well as state security. So there are a lot, even the operational structure of NAT joints is co-chaired by the same two departments. So hence then we feel that the bill will come in handy to strengthen the mechanisms that are in place already. Thanks, Chair.
General?
Those are our responses, Chair.
Honorable Hendricks?
We're having a bill, General Intelligence Laws Amendment Bill. We want to know, where does the buck stop? And I've suggested that does the buck stop with you, or is it the Minister of Intelligence?
I'm not very sure whether I understand the question.
The question, Honourable Chair, is that we've heard that the different departments must work together. We know that there's immense rivalry between these departments. We've now heard that the National Commissioner can't dictate to whoever's in charge of defense intelligence and other intelligence. So it's each one on their own. Now, how can you have different bosses if everyone is supposed to work together? It's somehow something needs to be done, that there is a name in the box with all the necessary support, So while everyone does their own thing and try to outsmart and outdo one another, which has been the case if you listen to media reports and so on. When I sat with the president in that committee with party leaders, he was questioned and he couldn't answer the question. Whose name is in the box for the failure? And you had the Minister of Police say, yeah, the defense intelligence people didn't inform them, and this one didn't inform them, and the defense said, no, but the communication was there in the cloud. Let's call it a cloud. Nowadays, you know, with artificial intelligence and so on, there's a cloud. But if people don't access it and act on it, so now they say, yeah, but you know, that came from defense. It's nice for us to know that is happening. So no one takes responsibility. That is my concern, Chair, that if, in this case, the SAPS intelligence says we can't do our work if we don't get information from other departments. I just feel that there needs to be a name in a box. And I was asking the question, is it the Minister of Intelligence? Now, we play an oversight role in the Joint Intelligence Committee. Is the chair there, the person whose name is in the box, that they must do proper oversight and make sure that everything is put together? Thank you.
Well, if I was to explain in relation to that, the bill talks about intelligence structures, not specifically for CI or for SSA or DI. It talks about, and it explains who must do what, and some of the things that you are talking about might be operational, which would be in the regulations. But it talks, that's why we called them, all of them, to come and give input. So they are responsible in their own right, in their own constituencies. There's no way in which there can be a bill that deals with, can't be responsible for SSA or DI if, that's my understanding. So they give their input, or RENA SCI, this is what we are going to do. Otherwise, it will mean that we must just have one intelligence structure, which is not possible. Defense deal with their own, and SSA, they will deal with their own. That's why they can't go to court. It means they are forced to share the information that they have because they can't go to court. I always joke about them when they are being given certificates, or where do they put their certificates? They can't even put them in their home. The certificates go into the wardrobe immediately. So that is my understanding of the situation. I see Honorable Hadebe with an H.
No, thanks, Chair. I thought your first response sufficed because you did mention that there's NICOC and there's net joint. And now if I were to expand that, NICOC is the National Intelligence Coordinating Committee, which is an organization that is responsible for coordinating the actions and activities of all South African intelligence agents and collating the intelligence information received. So there is coordination under NICOG. There's still a net joint, yes, which is a National Joint Operational and Intelligence Structure, which is also coordinating all security and law enforcement operations throughout the country. I thought we I would have said Ivali, fine, and then we proceed.
I was just about to say that, or even though Ukodisa School Office, you are boasting with your knowledge. I think some of these things, maybe Honorable Hendricks, some of these things we might talk about them when we deliberate. You might be, it might be not right to expect the officials here to answer some of those questions. You are the lawmaker, and the buck stops with you when we deliberate, and then you can put those things in there. They are just giving us inputs, not that it's already, whatever they say is going to be in the act. So I think we might be backing to the wrong tree, which might be unfair to them. So you can note them when we deliberate as a committee. Then we can put in those things. Whatever they gave us is not final. Any member? My general? Any other thing?
Nothing from Wasacha.
And the general at the back was very, very quiet. Unless if he's simply your bodyguard. It's possible. Okay, if there's no other input from our SAPS-CI, then can we, this portion of the meeting, can we say it's adjourned? And then we go to the next item on the agenda. 5 minutes break will do.
Thank you, Chair.
Good morning once again. Goeiemorgen. Can we get seated? Thank you very much. Morning once more. The second item on our agenda is inputs from the Office of the Inspector General of Intelligence. Can I hand over to the inspector? Over to you, Inspector.
Chairperson, good morning, and good morning to members of the committee and the others present. Chairperson, our presentation with respect to the General Intelligence Laws Amendment Bill is divided into three parts. We are proposing some amendments to the Intelligence Services Oversight Act, the act that governs the role and function of the Inspector General.
Is the sound fine for everybody? Okay, now you can continue.
Chair, I'll perhaps maybe speak a bit louder, yes. Thank you. So, Chairperson, as I've mentioned, the first set of inputs is with respect to the Intelligence Services Oversight Act, the act that governs the role and function of the Inspector General, among others. The second part is the inputs into the Strategic Act 39 of 1994, and finally the Intelligence Services Act 65 of 2002, which regulates primarily the administration of the civilian intelligence services. Chairperson, by way of introduction, I want to preface our input with the recognition and appreciation that our Constitution provides for intelligence services as an essential part of our architecture and our democratic architecture. So essentially, it recognizes intelligence as a force for good rather than some alien concept or something alien to democracy. However, we all know that the effective functioning of intelligence is also dependent on secrecy, powers of intrusion, and also the ability to manipulate intelligence outcomes. And all of these powers are incompatible with the features of a democratic state. Now, having said that, the Constitution then recognized that in the absence of safeguards in respect of all of these powers, that the intelligence services are not only a force for good, but can also threaten our democracy. In order to balance these competing interests, the so-called paradigm, the need to balance democracy and secret intelligence was also recognized in the very same Constitution, where the chapter on security services provided for the proper regulation of intelligence. That intelligence is a regulated industry and must operate within a set of rules and systems of control on the one hand, and on the other must also operate with a system of oversight to ensure that they serve the purpose that they were created for. So in this regard, Chairperson, that the mechanisms for oversight and control were established in law, in the Constitution, and there's a proper system of checks and balances in our own democratic system. These checks and balances vary from executive oversight, the oversight of the Parliamentary Committee on Intelligence, the only legislative oversight in the world that's established in law, as well as a civilian inspector general of intelligence, together with the elements of the judiciary, will also play a role in the oversight of intelligence. So, Chairperson, I think the important comment to make is that all of these different elements of the system of checks and balances, they serve as a form of public consent for digression from the provisions of the Constitution. And they serve as a consent for intelligence practice and also give credibility for the practice of intelligence within a democratic society. So it's important for the system of checks and balances to work properly. Moving on from there, Chairperson, that in this regard, with that background, then civilian monitoring of the activities of the intelligence services was legislated for in Section 210 of the Constitution, which provides that the objects, powers, and functions of the intelligence services must be regulated through national legislation, and also provide that there must be civilian monitoring of the activities of the intelligence services. So that made clear that intelligence functions in a particular context, and intelligence on its own is an undemocratic practice, that it needs to function within a system of checks and balances, including oversight. The oversight I make reference to, Chairperson, the role and function of the Inspector General is established, as I mentioned, in terms of Section 210 of the Constitution. And Section 210 is given further expression by the Intelligence Services Oversight Act of 1994 that articulates the role and function of the Inspector General and provides for two broad categories of work. The first is the ombud function, where the Inspector General is required to relate to members of the intelligence services as well as members of the public and investigate all sorts of abuses and maladministration. The other is an assurance function, where, given the nature of intelligence, the Inspector General is required to provide assurance to the public through the Intelligence Committee that the intelligence services are conducting their affairs in a legal manner and compliant manner, as well as being capable and operationally effective. They're serving only their statutory mandates and nothing else. So that assurance is very important. Chairperson, given that assurance and that role and function in that context, the Oversight Act, read together with the Constitution, also provides that this Inspector General must serve impartially, independently, and perform his or her functions in good faith and without fear, favor, bias, or prejudice. So these are important elements to ensure the credibility of the work of the Inspector General in order to convey that assurance. Now, having said this, Chairperson, the current institutional and administrative arrangements for the Inspector General are incompatible with these requirements and these provisions, where the current dispensation causes the Inspector General to be subservient in some respects to the intelligence services which he or she oversees. And this, in many respects, it may restrain oversight. It also has an adverse effect on the impact of the Inspector General and also the perception of the trustworthiness of the Inspector General in the eye of the public, especially with respect to the ombud role. So, Chairperson, this was recognized over the years. In fact, it was first recognized by the Matthews Commission back in 2008, and also a review conducted in 2006, and later the high-level review panel in 2018 recognized that there were fundamental flaws in the organizational and institutional form of the Inspector General, and reforms were required in that regard. And this later was endorsed by the Zondo Commission of Inquiry, and also the findings of the Zondo Commission of Inquiry, as well as the high-level review panel, were then endorsed by Cabinet and the President. And that gives the context of the amendments that we are proposing. So all of these commissions of inquiry, they recommended an independent status to allow the Inspector General to have full control of the financial, human resources, and the administrative activities of his or her office. So, Chairperson, the amendments, therefore, are proposed to give effect to this requirement of autonomy in alignment with an appropriate institutional form for the Inspector General outside of the GILAB process. But I also want to say, Chairperson, that in conceptualizing the nature and form of independence, we must appreciate that the Inspector General operates outside the intelligence services but inside of government. One must also understand that we operate outside the services but then outside their influence. But it's important to give due regard to the sensitivity associated with secret intelligence and the oversight thereof. So any dispensation or arrangement, institutional arrangement, must have due sensitivity to the nature of work being overseen. So, Chairperson, other than the institutional form and the autonomy we are proposing, furthermore, we are also providing certain recommendations to enforce certain clarity and enhance the performance of certain oversight functions which are contained in the presentation. Moving on to slide 6, Chairperson, with that background, these are the proposed amendments to the Intelligence Services Oversight Act, and I deal with the more, routine amendments first before I deal with those that deal with autonomy. With respect to the Intelligence Services Oversight Act, Chairperson, that the GILAB only provides definitions in the Oversight Act that give effect to the separation of the SSA into a domestic and a foreign branch. They don't deal with other definitions. And we are suggesting that the following definitions be included to provide greater clarity for the execution of the oversight mandate. Chairperson, monitoring and review the bread and butter of the role and function of the Inspector General, but they are not properly defined. The monitoring and review function are directed towards evaluating compliance by the intelligence services with the laws they are required to operate within, and also evaluates the performance of the intelligence services, but are not appropriately defined. And we are proposing a definition of monitoring and review in the ordinary context of their meaning. Third, Chairperson, is a significant intelligence failure. Our oversight dispensation includes a very interesting requirement where the head of an intelligence service must report to the Inspector General any unlawful intelligence activity or significant intelligence failure which may or may not have occurred in his or her service, and to also advise on appropriate remedial action being taken to prevent future recurrence of such failure or unlawful activity. But intelligence failure is not defined. So that defeats the purpose of the section. So we are proposing a definition of significant intelligence failure, which has been widely consulted in the intelligence community. Moving on to slide 7, Chairperson, further definitions, and it relates to proposal number 3, is a definition of unlawful intelligence activity, is to give a clear definition of unlawful intelligence activity, and what this would do is to cure a subjective discretion that currently exists on the part of heads of services on the meanings assigned to significant intelligence failure and unlawful intelligence activity, and seek to close any gap on this reporting obligation. Fifth, Chairperson, is fair presentation. Chairperson, for those who don't know, I want to share that the Inspector General is required to issue a certificate for every period of 12 months on the conduct of the intelligence services, mainly on their performance, but also on the extent to which they are complying with the necessary laws governing their activities. In the certificate, the Inspector General is also required to say whether or not he or she is satisfied with the report, intelligence report of the intelligence services. These are operational reports as opposed to the financial reports of the Auditor General. But the word satisfied is not correctly defined and needs to be given meaning in the context of communicating assurance. And this particular intervention is proposed in order to give meaning to what should be contained and what the role of the Inspector General might be, is to express an opinion on the fair presentation of the report of the intelligence service, and fair presentation is therefore defined. Chairperson, intervention number 6 is the definition of intelligence. And we've noted that intelligence is defined differently in the Oversight Act, and that differs from the definition in the National Strategic Intelligence Act. And for uniformity and standardization, we are proposing that one or the other definition is adopted. Number 7 is a technical matter that my legal advisor raised. The Constitution, the citation should be removed. Act 108 of 1996 is not necessary. That's not how the Constitution is cited. It's a technical matter. Moving on to slide number 8, Chairperson.
On that one, just want to understand what needs to be removed. Something in the Constitution or in some act, or?
Chairperson, is the Constitution 1996. The Act 108 of 1996 should be removed, the one in bracket. It's just the way we cite it, yes, the way we refer to it. We should refer to the Constitution 1996.
Okay.
I was expecting to be tossed out there.
Okay.
Sorry, Mr. Chairman, with your permission. They were given the opportunity to give input to this, to the Act. Are they now saying that all their input has been ignored and they're coming up with a dozen or two further amendments, which I hope we will look at more closely?
can I be, is there anyone who understands the question correctly? Honorable Stephen?
Chair, maybe if I can say to the Honorable Hendricks, that's exactly what we do. There is the proposed act, and we are listening to the various entities, what they see, what lacks, and they bring it to us, and we will further work with it in our deliberations and see what we put in and what we can't put in. So this is what they see fit to be included in the act. But it's not only the General Intelligence Law Amendment Bill, it's also the Oversight Act and the other acts, because there's a lot of acts that function, organize the functioning of intelligence services. And just to get a better clarity of that, that's what's happening. If I'm right.
That I understand it much better. So it means this is their first shot at trying to give input. They haven't given input to the department, for example, before.
Okay, can I just say, I wouldn't say it's the first time, because we had a workshop with them. They always come around, and in the meetings, they explain what are the impediments and so on. But that was done on our normal interaction. But this is specifically for the ad hoc committee, and it doesn't necessarily mean that whatever they say is going to be in the act. But what they are saying, this is what we think can make our job easier. You want to say? Okay.
Just
Honorable Kolaban.
Yeah, it strikes me that the question may be referring back, for example, to what we heard from NICOC. The ambassador said they gave all these proposals and the State Security Agency chucked them aside, which we then will consider. I think, am I correct? The question is, were these proposals given in for the creation of this proposed bill, and then have they been included? And it seems they haven't. So I think that is the thing. Have you offered it in or not? That's all we need to know. Were they in and then were they offered and then rejected, and now you've come to us, or is this the first time anyone has seen it? I think that's basically what the question is.
Can we then say that we give the Inspector General the chance to present, and then we will ask those questions at the end, especially because it's a general question. So can we give you a chance to present, and then we will ask those questions at the end?
Thank you very much, Chairperson. Chairperson, on slide number 8, these are further amendments to the Oversight Act. With respect to section 7.7 of the Oversight Act, the Act makes a reference to the role and function of the Inspector General and the scope. So I'm dealing with scope issues in terms of the scope of the mandate. It refers to the functions of the Inspector General in relation to the intelligence services. And today there's not a problem. But now we're undergoing a macro level reconstruction. You have domestic and foreign service. You also have the bulk interceptions going into a separate center, etc. And what this does is it then places interceptions outside the purview of the Inspector General, which I don't think what is intended. So the functions should be in relation to the intelligence services and the intelligence entities. That will allow a full scope of coverage, because that was a serious lacuna. Moving on from there, Chairperson, on intervention number 9, that 77A refers to the reports on monitoring and review investigations of the Inspector General to include findings and recommendations. And that really is a limitation, because the Inspector General has other functions as well. The Inspector General investigates complaints and should also make findings and recommendations, for example. There are other instances when ministers or the President may refer a matter for inquiry to the Inspector General, and there too findings and recommendations should be made. So this is a very limiting provision, and we are proposing that the 77A be amended to provide that the reports of the Inspector General contemplated should contain findings and recommendations for all functions, which is what we all do in practice anyway. And also, I think important for deliberation, which recommendations shall be binding. It's an important provision we are introducing, Chairperson. We found that in our most recent reports, we made 234 findings on all the intelligence services that were accompanied by 130 recommendations. And these recommendations, as well as findings, were subject to consultation with the heads of services and the respective ministers. So there was a consensus on the finding as well as the recommendation, and there's no reason why the recommendations should not be implemented. In the absence of implementation, the oversight would become irrelevant, really. We are proposing the binding nature of the recommendations. On item number 10, Chairperson, on slide number 8, is there's a provision, section 77C, that provides for the Inspector General to perform any function designated by the President, as well as the responsible ministers, being the Minister of State Security, the Minister of Police, and the Minister of Defense. There's no explicit provision here for the IGI to be designated by the JSCI, the Intelligence Committee. And we're proposing, in the interest of clarity, that 77C should be amended to include the JSCI, so the JSCI can also formally request any matter to be inquired into by the Inspector General, for clarity. Moving on from there, slide number 9, Chairperson, is also on the Oversight Act, but I move from issues of definitions and scope into issues of independence. That I have given the preface that Section 210 of the Constitution provides for the civilian monitoring of the activities of our intelligence services, and that a number of review commissions raise concerns that the requirements of an independent Inspector General is not provided for in legislation, that the institutional forms are lacking, and that some sort of arrangement needs to be instituted to provide for greater autonomy for the Inspector General. And Chairperson, what we are proposing, and I want to mention, and it will also relate to the Honourable Member's question, that the current GILAB, in fact, it further even limits the autonomy of the Inspector General. If it does brings about any changes, it further limits the autonomy of the Inspector General. And what we are proposing is that certain provisions need to be introduced. This will be in parallel with an institutional form. The Minister of Public Service and Administration has been canvassed by the Minister of State Security upon consultation with this committee during our earlier workshops to look at institutional forms. And that is a parallel process. But certain amendments are also required to the Oversight Act. And the first amendment refers to Clause 11 in the amendments. This amendment provides that the Minister must, after consultation with the Inspector General, appoint persons to the office of the Inspector General. So it would require every staff member, even at the lowest level, to require the Minister's involvement in the appointment of staff. Furthermore, there's also a provision in Clause 11 that the Minister must determine the organizational structure of the Inspector General. So all of these are limiting the autonomy, and we are proposing that a new provision be inserted in the Oversight Act to replace the current Section 712, which should read as follows. The Inspector General may, subject to this Act, do and cause to be done all things necessary for the efficient superintendence, control, and functioning of his or her office, including the appointment of persons to the office and the management of the budget as prescribed, which would require compliance with any rules applicable to the intelligence services, as well as the Public Finance Management Act, the Public Service Act, Intelligence Service Regulations, etc. So it's within that scope, but it's for the Inspector General to determine these matters rather than the heads of the intelligence service. So really, that is an all-encompassing provision to allow that autonomy over the budget, as well as the appointment of staff. and the institutional form will complement it. We are looking for an institutional form that is inexpensive, that doesn't bring additional cost to the state. Moving on from there, Chairperson, on slide number 10 is the certification function. Chairperson, I mentioned earlier that the certification function is an important instrument through which the Inspector General communicates assurance to the public through the Intelligence Committee, the JSCI, on the conduct of the intelligence services. In this regard, the current Section 11C dealing with the certification function states that the certificate stating the extent to which the Inspector General is satisfied with the report of the service must be submitted in the appropriate form. So what we are doing, we are bringing clarity by providing that instead of using terminologies that are not catered for in assurance functions, that satisfied should be replaced with express an opinion on the fair presentation of the report of the intelligence services. This will provide the greater clarity and a better level of professionalism around the certification function of the Inspector General. Chairperson, moving on to slide number 11 is regulations in the Oversight Act. Section 8 provides for regulations to be issued by the Minister of State Security in this instance, acting in concurrence with the Joint Standing Committee on Intelligence. There's a discretion to issue regulations on any matter that requires regulation. So what we are saying, Chairperson, as is intervention number 14, is that clause 12, the Minister acting with the concurrence of the committee must make regulations regarding the performance of the functions designated to the Inspector General. This is a fundamental error in the new GILAB, which limits the powers of the Minister and the JSCI to only issue regulations for the designated functions of the Inspector General, where the Minister and the President designates a function to the Inspector General. It excludes all other functions. And there are many functions of the Inspector General that require regulation. So we are proposing that the current provision in Section 8.1b must remain unchanged. It's actually fine in its current form that it enables the Minister and the JSCI to regulate any matter in the Act that requires regulation. And the current amendment limits that power for reasons unknown. Moving on from there, on slide number 12, Chairperson, we are now going to part B, it's the National Strategic Intelligence Act. We are moving away from our own Oversight Act. Clause 1 is a definition of intelligence gathering. This apparently replaces a definition of covert intelligence. The definition of covert collection was deleted and replaced by this definition of intelligence gathering. However, if one takes a closer look at the definition, it conflates intelligence gathering with intelligence analysis. So it's either the definition must be limited to intelligence gathering, or a better definition of covert collection must be provided. So there's a definition problem in the Strategic Act. Number 2, Chairperson, is Clause 2. Clause 2 provides that the intelligence services shall impede and apprehend members suspected of contravention of this Act and related regulations and hand them to the relevant law enforcement agencies. So what we are asking, Chairperson, that apprehend confers the powers of arrest. It's unclear whether intelligence members have now been given the powers of arrest, that in the absence of any offenses or any provisions for any offenses in the National Strategic Intelligence Act, it's uncertain how a contravention will in fact take place. So also further, Chairperson, that's from a technical point of view. From a substantive perspective, the power to apprehend, which is to arrest, resides with the SAPS. To confer these powers to members of the State Security Agency seeks to undermine the intention of the Constitution and the White Paper and counters the segregation of functions between the SSA and the SAPS. So it's something that we'd like to raise. Thirdly, Chairperson, in terms of Clause 2, the Clause 2 provides that a periodic national security briefing should take place to a number of parties, including the Joint Standing Committee on Intelligence and presiding officers and even the Chief Justice. And what we are saying is that the scope of the parties included in this provision needs to be reviewed. Also in the context of separation of powers, that in other jurisdictions, intelligence services wouldn't necessarily brief the judiciary because of the separation of functions. We are raising this as a matter for consideration rather than prescription. Moving on to slide 13. the Intelligence Services Act 2002, this is Part C, Chairperson.
Maybe if you were to repeat that clause 2 again, number 3, can you repeat that? I seem to have missed something.
Yes, Clause 2, Chairperson, it provides for the periodic national security briefings to the Joint Standing Committee on Intelligence and other parties as well, to premiers or members of cabinet, presiding officers and the Chief Justice. That what we are saying is that we are inquiring into the rationale for the inclusion of these parties, because it would also raise issues of the separation of powers, that in other jurisdictions, the intelligence services don't ordinarily provide briefings to the judiciary. And there are other parties there, the president and other important members of the executive are also excluded. So we are suggesting that this clause be reviewed in terms of the context of why and whom should be provided with these briefings.
And you don't have a suggestion?
No, we don't. We have a suggestion in our presentation here, Chairperson, that you must include parties such as the National Security Advisor and the Inspector General. But beyond that, we don't have any. Yeah. Slide 13, Chairperson, is the Intelligence Services Act. The definition section in terms of general provisions. Clause 13 refers to civilian intelligence structures. It defines the agency, the service, and the academy. Then it also, in terms of the provisions, the civilian intelligence service is not defined, despite it being referred to in GILAB. So to avoid ambiguity, we should create the necessary definitions of what is a civilian intelligence service, the emphasis being on service. Second item, Chairperson, is Clause 32, that no member of the civilian intelligence service may strike or induce or conspire with any other member or person to strike. We are suggesting an amendment that there is a balance in terms of Section 23 of the Constitution read together with Section 36. On the one hand, the individual may not strike, but on the other hand, the employer may also not cause a lockout, and that is missing in this provision. So we're suggesting that no member of the civilian intelligence service may strike or induce or conspire with any other member or person to strike, nor may the employer cause the lockout of a member or person. So we are introducing the last bit from the no, may the employer cause the lockout of a member or person. Chairperson, in terms of Clause 32, currently the minister must in the prescribed manner make provision for internal rules to deal with complaints, grievances, and consultation on conditions of service and human resources within the civilian intelligence service. And we're suggesting an amendment that is underlined in the presentation, that the minister must in the prescribed manner make provision for internal rules to deal with complaints, grievances, and we are adding alternative dispute resolution mechanisms and consultation on conditions of service. Chairperson, this is to provide for the independent dispute resolution mechanism outside the management hierarchy of the SSA. Because as we know, the SSA doesn't have a CCMA or a bargaining council like we have in the public service. And in our experience, this has led to a lot of abuse and management dereliction of duty. And this has a fundamental impact on morale within the agency. And we need this dispute resolution mechanism outside the management hierarchy. We've also proposed it in our recommendations to the committee, and we are suggesting that this would be a very important way forward in terms of collective bargaining, as well as the resolution of disputes outside the hierarchy of management. So, Chairperson, in conclusion, one wants to mention that Section 210, which provides for the civilian monitoring of intelligence through the Inspector General, also requires that national legislation must regulate the objects, powers, and functions of intelligence, including the Defense Force, as well as the police, the intelligence divisions of those two departments. So what one is also suggesting is that intelligence is a regulated business, and one welcomes the provision in the GILAB 2023 for regulations to be issued within 24 months after the commencement of GILAB. We say this because there is a missing layer in the regulatory framework in the form of regulations where matters of importance, including intrusive measures, counterintelligence investigations, coordination of intelligence, are not regulated at the level of ministerial regulations, and this compels the executive to regulate within 24 months so as to respond to that missing layer in the regulatory framework. We also note the bulk interception was declared an unlawful practice by the Constitutional Court, and GILAB 2023 provides for the legal basis for bulk signals interception. But I'd also like to add there, Chairperson, that way back in 2008, the Inspector General made this finding and the same recommendation of the court that the bulk signals interception was not regulated in law as provided in Section 210 of the Constitution, but the recommendation was disregarded and it found its way into the court many years later. So I'm also emphasizing the need to implement recommendations and to make binding the recommendations of the Inspector General. So, Chairperson, we want to welcome the GILAB other than the comments we've made, and that we want to also express a concern that in its current form, the GILAB 2023, contrary to the recommendations of the 2006 and 2008 commissions, as well as the high-level review panel and judicial commission of inquiry endorsed by Cabinet and the President, that call for the independence of the Inspector General, in effect seeks to limit, and in other areas it fails to address the Inspector General and the independence of the Office of the Inspector General. So our proposed amendments to the Oversight Act will provide this necessary independence and regulate the reliance on the intelligence services to provide a greater level of credibility for the oversight function, and also bring about a more effective oversight regime. I thank you, Chair.
Thank you very much. Maybe if I was to clarify, I'm not a legal guru. On slide number 13, point number 2, on the lockout of a member or persons. Doesn't a lockout happen when you are on strike? And maybe what would be because you are not supposed to be striking. And how do they lock you out? Lock you out. Would suspension mean some sort of a lockout? That would be my question on that one. And the suggested amendment on 12, slide number 12, number 1. Intelligence gathering means the acquisition and dissemination would that be correct? Or if you are gathering, it includes even dissemination. Wouldn't that be another function different? Just for clarifications on those ones. And to my members, Honorable Kola Barnard, followed by Honorable Stebe, followed by Honorable Hendricks, followed by Honorable Wate.
Yeah.
I'm not sure about the Honorable H.
Okay.
Okay?
Thank you. Thanks very much to the Inspector General. I think this does include much of what we have discussed and what we agree is necessary. Could you just point me to the amendment that would put you, and I mean you spoke earlier of the need for a separate budget, a separate entity to give you an equal status, because that is an issue that you're basically recommending from a point of being seen as a lesser body than the three entities. And I think that's got a lot to do with the resultant recommendations not being implemented. So I think that whole I mean, I see in clause 11, okay, you must be able to determine your own organizational structure, grading posts, etc. That's pretty much what NICOC said for themselves. But would it be in clause 11? But I can't quite see it. It refers to disciplinary it says manage the budget. Is there a specific proposal that says we want a separate budget? Have I missed it? It says you want to manage your budget, but it doesn't say you want a budget away from the SSA. So maybe I've missed it. Please just fill me in there.
To add on that one, on the recommendations, they are not binding. And usually with your certificate, you go and you discuss with the minister. And in a situation where you disagree, on the recommendation, on your findings, it means you won't agree on the recommendations. So in such a situation, if the recommendations must be binding, what happens? Honorable Stebe?
Thank you, Chair. If I can say, what we see here is a lot of proposals. We'll have to go back and we'll see where we can fit that in and how it fits in with what the current act before us, where it can be changed. However, I see that if you look at clause 11, 12 and 13 on page 9, it's in line with what NICOC also envisaged. And I think that is, as a JSCI, we're also looking at that, which is very positive to me. However, there's one thing in your proposal or amendments, what I don't see there is that in the Oversight Act, you don't mention a Deputy Inspector General. And I think that Deputy Inspector General must overlap with the Inspector General's term of office, because we see it was since 2010 that I'm with this committee. Every time there's a change of an Inspector General, it takes a couple of months before the next one is appointed. And I think for that interim period, and then the Inspector General's office is not able to work, not able to produce a certificate, and everything is afterthought. And it happened to yourself. You came in after, and you couldn't write the certificate on on a certain date. And I think that must be one of your proposals that we can put into the change in the Oversight Act of '94. Maybe you might consider that. And then there was one thing on clause 2 on the National Strategic Intelligence Act, B2 and 3, where you talk about apprehend confers the powers of arrest. Now, intelligence service, per se the SSA, hasn't got powers to arrest. But it's very clear that if there's something, they must, if up to a certain point, they can investigate and they can gather information, but at a certain point, that information must be given over to crime intelligence if there's any arrest. They can't arrest. I've never seen that's been changed in law or in any of these acts. Maybe you can enlighten me on that. Okay, I'm also of the opinion of the strike action, the lockout clause. Thank you. Chair, I'll stop there.
Honorable Hendricks.
Thank you very much, Honorable Chair. Honorable Chair, I just want to, before I make my,
Honorable, step your mic.
before I raise some issues, to put this whole matter in context. And we know that there has been an absence of Inspector General of Intelligence for a period that was unacceptable to civil society. And civil society felt very strongly about this because it's their constitutional right that there must be civilian oversight over our intelligence forces. So there has been, in our last 30 years, because we had a governing party from the liberation movement in place. So we overlooked many things. But then there is a chance that going forward, we will have the old apartheid regime back in power. So we can't be soft on this particular bill. And we have before us many changes to a bill that has been designed to undermine civilian oversight. So the GILAB bill, with all its good clauses, has been designed to undermine civilian oversight and to undermine the Constitution. That's why I asked the question, because when I saw the many amendments that had to be made, my first round thinking was that was deliberate. So this tendency to undermine civilian oversight, I think this committee must look very carefully at the amendments proposed by the Inspector General of Intelligence, because he is the champion of the streets. The people shall govern. Not intelligence forces which has been infiltrated by foreigners and foreign intelligence forces since the dawn of our democracy. So I feel, Chair, you mentioned the fact you're not a lawyer, you're not a legal eagle. Neither am I. So we need to not lightly discard the amendments, because it has been my experience serving on many committees when bills are looked at this level, at this stage, we hardly make changes to the original bill. This is a bill, there has to be substantial changes. And we must specifically protect the rights of the streets in this particular bill. We cannot be lax as we were during our last 20, 30 years, because there's a real chance that that the streets will have a hostile government in place, and that that all the gains that we had getting our democracy will be lost. So we mustn't ignore the recommendations of the Inspector General of Intelligence. Even, Chair, if you need further legal opinion to find out, are there any merits in what the Office of the Inspector General has put forward to us. So I feel that, this is a very useful presentation. It must be taken serious, and this portfolio committee, we must give preference to the streets. Thank you very much, Honourable Chair.
Yeah, thank you, Honorable Hendricks. I think I will be repeating for the third time. Each time you talk, you deliberate. And that we are going to do, we are simply receiving inputs. So when we deliberate, I said the buck stops with you as a member of the committee. Those are the things that we are going to put in as we deliberate on the inputs that have been given by all the services that were. So it will be ourselves deliberating, saying now, okay, this suggestion doesn't hold water, or they forgot to put this one in there in terms of their independence, or they omitted this, which we will still be communicating with them. Or what do you think about this? Why didn't you put this in there? And so now let's deal with their inputs to clarify how they view some of this thing. After which, it's possible we might throw every other thing out, or, it's not practical, whatever you. But that would be for the committee to decide, because they are the ones that are making laws. So we are still going to deliberate on what they told us. Because input, you can say anything that you want to say in your inputs that serves you right. But we are still going to check whether does it have weight and so on. Because if we do it that way, we're actually putting them under the bus and they can't answer those questions. Honorable Luate.
Yeah. Chair, maybe through you, because I don't want to, we have been around this, trying to find an interpretation on some of the words. Because on that slide 19, that word has come back again. Now, maybe just through you,
Saying slide
no, not 9 point, point 13. Yeah, because this word has come back again, and I'm asking myself, maybe if from the office of the Inspector General can just tell us, how do they understand that word may in their own context? Because it's coming back for the second time, and if you follow, there might be something here that we might not be seeing, because when you look at the initial clause 11, you'll find that the word is there as it's contained currently, but going to the other side in the recommendation, the word comes back again. So I just want to find out in the Inspector General's own understanding, what would this mean? Then the second question, it's on the issues of making binding recommendations. That are there any suggestions or ideas around what the office see as powers that they might need, or whether do they really need powers to enforce recommendations that they make? Thank you, Chair.
Yeah, I think that goes along with the question that I posed, or what is their understanding of binding? Because they've got to sit down, converse with the minister, and the minister says, no. This is angiboni kanjalo, and they disagree. So how do you circumvent the binding in a situation where you disagree? Okay, Honorable Hadebe with an H.
Thanks, Chair. I also wanted to raise an issue on that one. That if they are binding, does it mean if you are aggrieved, you can challenge it? And if challenged, will it be the same as the public protector that you challenge them in court? If you disagree, is there a recourse in mitigating the disagreement? In your understanding, why do you think the high-level review panel report did not make such a recommendation and left it for further deliberation and research? Are there any benchmark or case studies in other countries where the office similar to yours have binding recommendations, so that perhaps you assist in supporting your argument of binding a recommendation? I'm worried about a situation where there will be a dispute after another in terms of not willing to accept the recommendation if there are no measures in place to ensure that those that are not in agreement with your binding recommendation should pursue a less confrontational path. I'm hoping it won't necessitate the court action to set aside your recommendation, because you said in your motivation it should be an offense not to implement your recommendations. Thank you, Chair.
Thank you very much. Just to add on that one, the aim here is to remedy a situation whereby the services just ignore all the recommendations and nothing will happen. That is the aim of trying to solve. But in what way are you going to do that? That's what we would like to find. How do you envisage doing that? Especially in a situation where you disagree. Otherwise, we are going to take millions. And in a situation whereby somebody takes, SSA takes you to court, or you take SSA to court, you've got to use their purse anyway. Must they give you money to take them to court? So on some of those things, Honorable Magwanisa, followed by Honorable Kolabana.
No, sir, a very short, brief one. Is it really a correct word to be used to say recommendations should be binding? Because I think that if you want that to take that route, it should be remedial actions. But to say, because recommendation is still subject to the person we are making recommendations to. It's not a decision, so it can't be binding. So maybe they should think about a different wording to express what they want to see. But I doubt that the recommendation would be an appropriate word.
Yeah, we've got legal gurus in here. Honorable Hadebe with an H.
I'm just thinking now, how about if we say when accepted, then they are binding?
No.
As I said earlier on, all of them are not accepted. So there will be such a situation. Well, let's see here. I mean, it's simply a question of getting a clause that would make these things workable. As per recommendation of all of those commissions, they definitely recommend on this issue. Honorable Kolabana.
Yeah, I also would like to see added to that, or what is envisaged. If I'm crime intelligence and I receive the certificate and he says there are the recommendations, and I say, well, that's interesting, and I walk off and I don't implement them, what's the next step? Because then is the minister clubbed? Is the DG clubbed? Is anybody, and what clubbing is done? Are they fined? Are they jailed? What is the situation? Because there's nothing envisaged in terms of the outcome of a refusal, because I assure you there will be one.
Honorable Stebe, followed by Honorable Hendricks.
Chair, I think what's been said is that there must be clarity. This is the parameters in which we work and what we can do. If I must take an example, it was classic one was with the certificates, where there was a mention made of the DA, and not the DA party, but the defense attaches in other countries, which doesn't fall under defense intelligence. They fall under DIRCO. That was just one issue, just to get that in the clear and say, till where do we work? What can we do? What can't we do? And where is our responsibility? Is it just in the security cluster? If it's a security cluster, it might include, but if it's the services, then it must exclude. Just to take that in consideration.
Honorable Hendricks.
Yes, Honorable Chair, I want to have clarity on whether we've heard that employees are denied a fundamental constitutional and human right, the right to strike. So let's find out, for sake of clarity, is there a grievance procedure with management? And I would imagine that if there was a grievance procedure, that at the end of the grievance procedure, you now move outside let's call it the company, and you seek help elsewhere. So we heard that people can then go to the CCMA, but that is not possible. So when we are going to look at that particular amendment, my suggestion would be that if the grievance procedure fails to resolve an issue between the boss and his employees, and they are not allowed to join a trade union where collective action can be taken, where they can go on strike, shouldn't there then be provision for arbitration in two forms? Number one, advisory arbitration. So maybe the employee accepts and at the end of the matter, and both parties are quite happy. Or must it be compulsory arbitration? So would that be a solution? But it can't be a solution if there's no grievance procedure in place. So I want to know, is there a grievance procedure in place before we go outside management to try and resolve the disputes? Thank you.
I think maybe I heard them say that's one of their suggestions in relation to that issue. They even said it must be an independent whatever. Okay, can I then go back to the Inspector General on those questions.
Thank you. Thank you, Chairperson. Chair, thank you for all the questions. I have my colleagues with me, behind me, a legal advisor on my right. Mr. Njabeling is also an authority on the human resource dispensation in the intelligence service. So I'm glad I have him to answer some of the questions. Chairperson, just to deal with some of your comments, I will defer the lockout to Mr. Njabeling. You raised the issue of intelligence gathering and dissemination. I think that is the point there where the recommendation is made that the gathering is separate from dissemination. The dissemination is a different part of the intelligence cycle, and that is why the definition is inappropriate. So that's just a technical issue. Then there was a lot of discussion, Chairperson, on the binding nature of the recommendations, as well as Honorable Kola Barnard raised the key question that we understand the lack of independence, the need to manage the budget, need to manage appointments, and to operate free from influence. But where's the silver bullet? How are you resolving it? And I also need to answer to that. So let me start there, Chairperson, then others can follow. With respect to the independence and the institutional form, I think what is important to also state is that the resolution of the independence is dealt with in two parts. The one is in the Act itself, certain amendments proposed, but the other is also in the institutional form that is adopted. That process is running in parallel with this one. And what one would want to say is that there is currently research being undertaken on the most appropriate institutional form for the Inspector General. For example, you cannot be a Chapter 9 institution, such as the Auditor General or the Public Protector, because that is settled. The other options, for example, would be a Schedule 1 department, like the SSA itself. But that comes with huge expense. It's for these huge departments, the Defense Force and Home Affairs and the others, so it's not appropriate. Then you have other forms of institutions, such as Schedule 2. Those are Schedule 1s, by the way. Schedule 2 is for ESCOM and Transnet, those who raise revenue. There are huge institutional requirements to establish them. And the third category is the Schedule 3 institution, in terms of the Public Service Act. A cheap form of institution that doesn't require additional expense would be, for example, a government component. In that instance, the government component would still be married to a department. So we could be married to the Defense Force or the police or state security as the main department. However, that department only exists as a channel for our budget. Once the budget is received by the Inspector General is then the accounting officer for that part of the budget. And there's still a minister of the relevant department who's the executive authority. But what it does is it creates a mini department within a department with full institutional autonomy and its own accounting officer. That allows the management of the budget in terms of the PFMA, as well as the management of the human resource administration and the career incidents, organizational structuring, is also with the Inspector General through the Public Service Act or the Intelligence Service Regulations. So the institutional form is very much part of the conversation. It's not only the amendments that give rise to it, but they must complement each other. And to complement each other, it's important to remove all clauses in this Act that require the minister to appoint a staff member or the minister to approve this, that, or the other, and also to remove any suggestion of the DG of the department being the accounting officer. Because currently we have that impediment where the DG of State Security has authority over the functioning of the Office of the Inspector General. It's something we repel very strongly to maintain autonomy. But that is why we're maintaining that these amendments on slide number 9 are introduced to allow the Inspector General to do all things to be done to effect proper superintendence, control, and functioning, especially with the budget and human resource management, as prescribed. As prescribed would be the PFMA, the Public Service Act, and those rules. So those two read together will give effect to institutional autonomy. So I hope I answered the question. So this should not contain any gremlins in this Act. All these provisions that limit and compel the IG to consult all sorts of third parties to do simple things like appoint a junior member of staff must be removed. And then the institutional form will then put it together.
Can yeah, can you finish all the questions and then you will take follow-ups later?
It's on this that we're talking about now.
Okay, proceed.
Thank you, Chair. Acting Chair, Deputy Chair, whatever you call. There's there's one thing that we must keep in mind. Even if it's a Schedule 3 institution, there must be oversight. And that oversight, you've got a minister, there must be a form of oversight from that side and from the JSCI. And that, if you're going that way, I think you must also mention that the oversight function will lie where it is now under Oversight Act 40 of 1994. We can't negate that. It's there and it can't change.
Yes. Yes, Chairperson, to confirm that fact, I don't know I think it's 7.6, I'm not sure. Sorry, it is? 7.6, it's 7.6. 7.6 requires the Inspector General to account to the committee for the functioning of the office. That is not touched. So those arrangements for accountability, they will remain. Both executive accountability and parliamentary oversight of the Inspector General is intact. So thank you, Deputy Chair. I see Chair is not back. So I deal with the issue of the institutional autonomy and the mechanics for bringing it about. The other issue is the question of the binding nature of the recommendations. And I believe that the issues raised are very relevant, that it could lead to all sorts of disputes where recommendations are not accepted. And we could create new problems by resolving this one. But the Chairperson also aptly mentioned that what we're trying to resolve is the challenge where recommendations are made and are not implemented. And the acting Chairperson, Deputy Chairperson made the comment as well, that where recommendations are accepted, it would create a different dimension. We counted up that we made 130 recommendations for the fiscal year 2023 to the services that were accepted. They were all accepted because we follow the Audi process that we go through the heads of service, we leave them with our reports for a period of time. And they comment, they don't agree with some recommendations. And we sit down with them and we have to change them because sometimes we interpret things incorrectly. And there are other times where we persuade them. But in most instances, there's agreement. So when we conclude our consultation process with the heads of service, we proceed to the ministers. And the ministers then sit down with us and satisfy themselves. And the ministers, from what I have gathered, the ministers see this as a valuable intervention for their own superintendents, that the services are now being overseen and their interventions in the form of recommendations to correct non-compliance or non-performance, as the case may be. So once it passes to the minister, there's also consensus. And the minister then transmits the reports to the committee. We don't transmit it, the minister does, because the minister agrees with that instrument as a set of recommendations to bring about change and reform. So I think we need to bring it together in that particular way, is to avoid conflict and to reword or to invent our own dispensation where the recommendations pursuant to consultation and agreement should be then seen as remedial action, which then becomes binding. We need to find a way around the words to prevent disputes and unreasonable recommendations of the OIGI that must be implemented, but on the other hand also avoiding turning oversight into a vain exercise where recommendations that in fact are agreed upon are not implemented. So Chairperson, I think it's all in the wording as yourself and the Deputy Chairperson has said, that recommendations must be consulted and agreed upon and turned into remedial action. We need to find the legal words around it. It's also possible, Chair, that it can find itself, and my legal advisor can talk to it, into a regulation where this can be spelled out. We can explore the possibilities of it going into the main act or into a regulation to ensure that we avoid all of these impediments in our quest to implement recommendations. And Chair, I also want to say, in this question, also the issue was raised of what powers are required to implement recommendations. So, we spoke about our practical experience, and we follow the Audi process. We consult. The recommendations are not in a vacuum. They are agreed upon. But also, in terms of powers, there's some recommendations we insist the services implement. It is non-compliance, it's quite straightforward. There is non-compliance, we could even refer it to a competent authority for further action if not implemented. So we do use the current resources at our disposal and the powers we have to in fact bring about implementation at any rate without the benefit of the binding nature of the recommendation. But what is also important to state that the most important power that is necessary is the power of access to information. Because without access to information, that's the oxygen upon which oversight takes place. There's full access to information that in terms of the law, nothing can be withheld from the Inspector General on any ground. And the services are compelled to provide access to all information, including to the staff of the Inspector General through relevant delegation of authority. That is a most important feature of our dispensation, is the access to information, that oversight is not impeded in any way. And it has been my experience since I've been appointed. There's been no limitation. There's been full structured oversight that we need to also inform the services and not surprise them. We need to make it clear to them what we are doing so that we all understand each other. And as a consequence, the level of cooperation has been phenomenal. So that is very important that we think about the recommendations, but the entire process is also something that is very much subscribed to by all parties. We're all together in this. So, Chairperson, to talk about the access to information and the binding nature of recommendations, I want to also acknowledge the comments made by the Honourable Stubber with respect to the Deputy Inspector General. As noted, my legal advisor will deal with the powers of arrest, and my colleague, Mr. Nchabileng, who incidentally retires this month, is an authority on the human resource dispensation in the intelligence services, because it's different from the public service dispensation. So we have the benefit of his presence today. So I'd like the two of them to answer that aspect of the human resource issues and the legal issues. And I also want to say that, Chairperson, in terms of the other comments, the minister and the organizational structure where the minister may bring about, that we propose that the Inspector General should actually take those decisions. So we're proposing, in fact, that those provisions be removed because it impedes the institutional autonomy we're trying to bring about. So we would like, that to take place. Yes, Chair, I think I've dealt with the issues. I'd like to ask my colleague, Mr. Nchabileng, to deal with the human resource dispensation. And then my legal advisor will deal with the legal questions, especially the powers of arrest. Please, Mr. Nchabileng.
Thanks, Chairperson. Honorable members, I think the starting point here is Section 23 of the Constitution, read with Section 36 of the Constitution. That provides for the regime of fair labor practices within all workplaces in South Africa. And all workplaces in South Africa are enjoined to act in accordance with the provisions of the Constitution. In the private sector and in the public sector, other than the civilian intelligence, actually even in the SANDF and in the police and in the nursing sector, essential services, there is collective bargaining, which is actually a must for all workplaces. But then the reason which was taken for the intelligence services was that they should be excluded from the general labor relations legislation applicable to them, but not to say that they are not going to abide by Section 23 of the Constitution. They will still abound, but a recognition was that they should regulate that within their own environment, considering the security nature of the environment. But what the services have done was, no, we don't regulate it. Actually, they remain silent about collective bargaining. But at the same time, there is individual labor relations regime for all workplaces in South Africa and collective labor relations regime in South Africa, which is provided for by the national legislation called the Labor Relations Act 66 of 1995. That regulates that environment, but the intelligence services were supposed to regulate themselves. But then, in terms of the strike, it is regulated in Section 23. But then, in terms of the Intelligence Services Act, it is actually prohibited, which is a fair thing to do, due regard being had to the environment, the security environment. It's not geared towards that strike. But the strike is an instrument used by employees to force the employer to accede to their demand. It is a known fact. It is an instrument legally recognized, and it provides for lawful strike and unlawful strike, but if it is regulated, it should be done that way. But other than the clause in Section 21 of the Intelligence Services Act, which just say a strike is prohibited, but it doesn't look at what the employer can do. It actually looks at the severity of the strike from the employee point of view. But it doesn't say the employer also uses a lockout as an instrument to force the employees out. But then the strike is intended to force the employer to accede to the demand. But then the lockout, which is a corollary of the instrument, collective bargaining instrument at the hands of the employee, but then the very same right of lockout by the employer is nowhere to be found. So the main thing is, if you regulate or you want to prohibit a strike in a legislation, then you should also look at a lockout within the, as a weapon, a similar weapon to be used by the employer. Currently, suspension is something different. Actually, suspension is well regulated within the intelligence environment, and it applies in the case of investigation of misconduct. It's not a collective bargaining measure. It is the employer suspecting someone to be involved in serious offense and who is actually seen to be, if he remains in the employment during that period, he may or she may interfere with the investigation. So the suspension process is regulated in terms of the disciplinary process. So it's addressed, it's not the same as a lockout. Now the chairperson asks, if people are not allowed to strike, why do you make an issue about a lockout? Because anyway, they are not supposed to. I think it's to level the playing field, to say a legislation should not necessarily be on the employer's side, but it should balance all the interests. Because collective bargaining, which is an imperative, it is something that has to be implemented and tailor-made for the services themselves. So tailor-made for SSA, they can exclude covert members totally, but to prohibit it it's unlawful and unconstitutional because the section says all workplaces, unless if then there is an exclusion in the Constitution to say members of SSA are not supposed to collectively bargain. But then, why then do you regulate an instrument of collective bargaining, but say nothing about the collective bargaining? Not to regulate it means they are actually acting unlawfully, because they must regulate it from a constitutional point of view if they don't have labor relations legislation applicable to them. But the intention of the legislature was that they should regulate their laws, regulation adequately, looking at what their own security, environment, and national security interest. Now they've got a very good grievance procedure mechanism, very good. But then the problem there is at compliance level. Management often may not be adhering to time frames at all levels. And certain members, when they have complained through the internal grievance procedure, they lodge a grievance, but it's not resolved for 2 years. And while the grievance procedure says it must be resolved within 10 days. Now it becomes so frustrating and demoralizing for members. And actually, if the more the member pushes for his or her grievance to be resolved, is labeled as a disloyal, maybe I will say, not necessarily that it has happened, but it is likely to be that a disloyal member. Members tend to come to the Inspector General to circumvent the grievance process because management do not take their grievances seriously. So as a result, IG has been receiving so many grievances in the form of complaints in terms of Section 77CA. So, and IG felt that no, in some instances, members had genuine concerns, but they were ignored. That is why the IG during this report, the report of the 2022-2023, the IG said that developed a position paper to say members of management must be able to resolve grievances. And dispute in terms of the grievance procedure, it must go to the minister. And there are clear time frames for the ministers to deal with them. But once a grievance goes to the minister, it matures into a dispute. If it is a dispute, it provides for adjudication mechanism at ministerial level. But even there were 2 years, some 2 years where members' grievances were at the minister's office without being resolved. And that led to demoralization, and members turned to the IG. But then the IG said, looking at the whole process, recommended to the minister that no, there should be a dispute resolution mechanism, which does not only look at arbitration, but it must be independent at ministerial level. Disputes which could not be resolved by the minister should find a way if they are genuine, because there may be vexatious and frivolous grievances. But those which are genuine must be certified to go to the next level, not necessarily to go to court, because members would not have money to go to court to fight serious cases. But they have something genuine that needs to be resolved. So the main thing is to create a mechanism, independent mechanism at ministerial level to deal with genuine cases as independent, because in the private sector, there is the CCMA. The members, if a grievance could not be resolved internally, up to the minister, even in the public sector, an employee, a public servant would still have that mechanism. That is not available for members of the civilian intelligence services. It's available for all, including members of the police, SANDF, but SSA dispensation is it is actually a recommendation there that it needs to be. So I have just outlined in greater detail what are the issues at play. Thank you.
Ms. Gangner, do you want to deal with the question, legal questions? Yeah?
Thank you, Chair. Thank you, IG. I think there's just a couple of issues that IG has indicated I should deal with. I think I will start with the question of apprehend. I think Honourable Stibber raised that issue as well, but I see he has left the room, but I will deal with it nevertheless. The question of apprehend is a new insertion in GILAB, which never existed before in the Strategic Act. We must be very careful because apprehend normally denotes arrest. And now SSA, the domestic branch, will now be given the powers to apprehend and hand over to law enforcement agency. The minute you use the word or arrest, Section 35 of the Constitution kicks in, where persons who are arrested have powers to remain silent, all kinds of powers that are listed in Section 35. So hence our concern was, when you say apprehend, taking into account that fair trial rights commence at the time of arrest and will have an impact on a fair trial, come to trial stage, what will now be the position of SSA? So, I mean, it's very, very clear. It will taint the whole process. If there is a solid arrest and is handed over, it will taint the whole process to a trial and the fair rights of the accused person. So that to us is a real concern. But over and above that, if you look at the amendment of that in GILAB, it talks about apprehend suspected of contravening of this act, contravening the Strategic Act. Now, there's always been a huge lacuna in the Strategic Act where there's no offences or penalties clause. I mean, there's no contravention of the Act as it stands because there's no offences clause. So now when you say contravention of this Act, contravene what? That was the added layer we added into the table, because we don't understand what is meant by apprehend, but our major concern is that we have to look at constitutional issues, Section 35 rights, when it comes to apprehend. So I think that needs to be re-looked at, or just a clarity on the intention behind the word apprehend. SSA does not have the powers or the functions to arrest people. That resides within SAPS. And it goes directly to the segregation of functions and duties. So that really needs to be looked at. On the issue, I'm just going to touch very briefly on one or two issues. On the issue of a Deputy IG, which Honourable Stibber has raised. Yes, Honourable Stibber, that has been raised as far back as 2016. The matter first rose in 2016 on the Deputy IG, and input was given, but with the protracted process of the GILAB 2016, 2019, then 2022. Even in 2022, when the GILAB 2022 was posted on the SSA net, the office did provide input, and there were numerous discussions between myself and people at SSA about this whole concept of a Deputy IG. And we were basically advised, well, that is not going to be looked at. But we do have it. We do have the input for Deputy IG as far back as 2016. I'm going to touch on an issue now with regard to the binding nature. I'm not going to go into what the IG has said. I think he's covered it adequately. Suffice to say, on Honourable Kola Barnard's question as to what, you talk about binding, but to what? But in our recommendation on the table, and the motivation, we did indicate that if we say binding, but there should be a complementary clause to say that if it's not implemented, it can be made an offence in terms of Section 7A. So I think that deals with that. So the suggestion around this room to say if it's accepted and not implemented, it can be made an offence, like failure to provide information to the Inspector General. And there's a way of amending Section 7A of the Act to cater for that. So I think that will cover it in that way. On the issue of may that someone raised, it is discretionary. But I think our purpose there, it wasn't must and may, because that power should reside with the IG, and the IG would have discretion should he or she feel that they need to reorganize the post-establishment of the IG. I think what's crucial for us to understand, Clause 11 of GILAB provides for the Minister may, on the determine the organizational structure and grading of posts in terms of the Services Act. That's 65. I think what the drafters of GILAB fail to understand is that members of the OIGI are not appointed in terms of the Services Act. We are not members in terms of the Services Act. We are appointed in terms of the Oversight Act. And the only thing that links us to the agency, so to speak, apart from the appropriation of budget, is the fact that we are bound, Section 712 of the Act says we are bound by the conditions of service as are applicable to the agency. And that is open up a can of worms when it comes to issues such as disciplinary matters and where do we fit in? In some instances, we are considered to be outsiders as the members of the IG's office. In other instances, we are considered to be members of SSA, which we are not. There must never be that confusion. Hence, it's so important in terms of Clause 12, and as the IG had said, that for the efficient superintendents of the office would go across the board and touch all the issues regarding discipline and matters of HR regarding members of the Inspector General. I'm speaking as a member, as with my colleague here, we cannot be subjected to any decision made by the DG of SSA, which currently we are. So it's those kind of issues which I think an amendment of Clause 11, as we have recommended, would cure to a certain extent until such time we are scheduled. But I think it will marry with each other once we are scheduled and these kind of amendments. But we are not saying this is all of the amendments we would like. In actual speaking, we discussed this in the office, what we would really like in the long run is a complete overhaul of the Oversight Act. Like with ICD and IPID, we have a bill where it just deals primarily with the Oversight Act. That will cure all our problems with regard to entrenching ourselves as an independent body overseeing the services. Just two more issues with regard to as prescribed. The IG mentioned as prescribed. We deliberately included as prescribed in Section 12 to ensure that apart from other legislation like the PFMA, etc., we can then use our Section 8 of the Oversight Act to then regulate exactly how the IG will deal with matters of grievances, disciplinary. Because we find ourselves, while Section 8 does provide for regulations to be made for the conditions of employment of members of the OIGI, it has not been done. So this will give an added push. And as the IG had said as well, this whole issue about this 2 years, the 2 years is commendable, but confining it to just functions designated does not make any sense. And another lacuna which has not been mentioned, Section 8, sub 1 of the Oversight Act, basically says that all matters permitted, any matter that is required or permitted to be prescribed in terms of this Act. This is discretionary, I understand, but that has been excluded from the 2-year time period. So hence, the limiting of 8B to just functions designated actually makes no sense because it can be used for everything else. I think the last issue I have to talk about is when it comes to the delegations, the IG did mention, it's actually, the current regime makes no sense because Section 20 of the Services Act, currently as it stands, says the minister may delegate powers, certain powers to the DG, and the MPD, that the Ministerial Delegation of Powers and Direction of Payment, deals with certain powers. But the GILAB is now included that powers may be then delegated to to the DG as well as the head of the director of the center, and there's one other person, if I can just look at that, in terms of that. But the current MPD, when it comes to appointments of lower levels, talks about powers being delegated of lower levels to the head of a spending center. Now, as we stand now, the IG is the head of a spending center, although we don't want to be a spending center. So it's actually a misnomer in the MPD to include those kind of delegations to the IG in the capacity of head of a spending center. So this will require a complete overhaul of the MPD, where any reference of that nature is removed from the MPD as well, because it's the IG, well, we're now saying the IG should actually appoint members to the office. I think that's about all the issues, unless I've missed out something. I've just gone quickly through all the other issues.
Yes, thank you very much, Advocate Governor. Chairperson, there's two things that are still outstanding. Honorable Stubber raised the question about the scope of oversight by making reference.
Advocate, you, Mike.
Sorry. Oh, thank you.
Yes, Honorable Stubber made reference to the scope of oversight in the defense intelligence environment, making a reference to the defense attaché program. Yes, Chair, through you, what I want to say is that the Oversight Act provides for the oversight of the intelligence services. In fact, we dealt with it earlier. The oversight is in relation to an intelligence service. And all matters within that intelligence service is subject to oversight. The Defense Attaché Program is a subdivision of the Defense Intelligence Division itself. There are 5 subdivisions within Defense Intelligence, and the Foreign Program is one of those subdivisions. So legally, it's subject to oversight. It also has an intelligence gathering function, the Defense Attaché Program. And for all reasons, in terms of the legislation, they should be subject to oversight. Clearly, it's a no-brainer. And I'm not sure why it led to any dispute, but where there is a concern is, for example, if the Defense Attaché Program is moved into the Defense Force under the direct command of the Chief SANDF, that creates another dimension. And it could happen even for intrusive measures, which is something we must discuss at the committee level, that you could place certain intelligence functions outside oversight by placing it in another part of the organization. That really is the concern. And then finally, I also want to deal with the Honorable Hendricks made the comments about the nature of the inputs, that we've not had the opportunity to make the inputs into this process. And as a consequence, we've had a workshop with the committee, and we shared all of this information. And we also wrote to the minister, and the minister acknowledged that we should make our inputs directly through the committee and in these hearings. That I'm not sure if there was any incentive for the services to welcome or even invite these sort of comments. If noting that some of the inputs and the provisions and the amendments are in fact limiting the oversight function. So this is our first opportunity to make an official input, and this has been discussed in detail with the committee during June of this year. So thank you very much, Chairperson, and thank you for the opportunity.
Thank you very much. Is there any other thing I can see? Honorable Hadebe, followed by Honorable Hendricks.
Thank you, Chair. When the IG responded to the issue of the binding nature of the recommendation, he did not speak about the process to review such, and whether or not there has been any benchmarking exercise from other countries to understand. Oh, sorry, Deputy IG. Whether or not it's a standard practice, Chair, that in other countries the recommendations will be binding. So I'd like to get a sense, Chair, so that when we apply our mind, we take the issue of review into cognizance, and it will inform our basis of considering the proposed amendment. Thank you, Chair.
Honorable Hendricks.
Yeah, Chair, I'm not sure if this is covered in other legislation that affects the IG, but I mentioned earlier on that the Constitution is very strong that there should be monitoring by civilians. And certainly one of the things that we want the IG to monitor is that we are not going to be tortured like we were in the days of apartheid. Is he happy that this is dealt with, or maybe advised that it's not necessary because it's covered in other legislation? Because if there's a civilian authority that needs to do oversight, torture is a very important thing. Especially if we don't have, a hostile government, but we could have one in the future that wants to torture. So this legislation is not only for the present government, but also for the next government that may not come from the liberation movement. So I just want to have peace of mind that the IG does look into matters relating to torture.
Okay, any other thing from the members? Okay, maybe on the question of the DA, as in defense attaché and not the other DA. I should think. Okay, I should think we got an explanation from defense on that issue, and I should think it was understood. Well, I think it's outside this process anyway, but it was understood that the chief of the army has got a prerogative to pick on any member in any unit and place them somewhere abroad, not necessarily in an intelligence capacity, even if that person might be coming from the defense force. It was well understood that if that is the case and that person is not in the intelligence environment, then maybe it's not within the IG's office to pick on that individual by the mere fact that it's in the intelligence wherever he or she comes from. I think we agreed on that one. Can only deal with the intelligence part of whoever is in the DA, or I mean in the defense attaché.
Really?
Honorable Stebe.
Chair, just to that, I think the test lies in that the defense attachés are not collecting intelligence. They might gather information, but that's not intelligence. And that's the difference. Intelligence, you're spying. To gather information, you can get it on the overt line. I think there's the crux of the matter. Thank you.
Yeah, I should think that's why I said outside this. I see most of the members here are already into the spying issue here. We are not on the spying issue. We are not spooks. This is an open meeting. But anyway, I just wanted to clarify that it might fall under this if maybe the inputs from the IG, they want something to be inputted in here, but I haven't heard anything about that. So it was just a by the way thing because it was mentioned. Any other thing from the members? Did I see Honorable Magwanisha somewhere?
He's out.
Okay, so if there's no other thing from the members, can I have Honorable Kolabana to thank? On the follow-ups, okay. IG.
Thank you very much, Chairperson, honorable members. Chairperson, Honorable Adebe raised the issue on the binding nature of recommendations. The first part is with respect to the review process. The conversation we're having, I think, also points to the fact that we need to avoid the recommendations being taken on review, and we need to introduce further steps and fail-safes in the system. And one fail-safe is to ensure that the recommendations of the IG must go through a consultation process, in which event, once they are agreed upon, they become remedial action. And we need to follow that kind of route to prevent recommendations being taken on review. Honorable Magwanisha, when he was here, made mention of the fact that a recommendation is not remedial action as such. So I think in the course of the conversation, we reconciled some of that to suggest that what we are talking about here is the need to have a proper due consultation with the affected people, the head of service and the minister. And it's only when a recommendation has been agreed upon by all parties, it then becomes remedial action, which is binding. So I think we want to avoid the review, but it is correct. And I was warned before we came here that if we propose that recommendations are binding, then we must expect to be taken on review in the courts. And that is correct, Honorable Adebe. We want to, I think, through this conversation, avoid that through our practical process. That the minister transmitted the recommendations of the IG to the committee. They were all agreed upon. So they should be considered to be remedial action, and that should be binding, not a recommendation, to avoid, disputes and being taken on review. To answer your question, the second part is a benchmarking. We were fortunate that earlier this last month, I believe in October, the 12th of October, we engaged in a roundtable with foreign IGs of a very mature democracy, one might add, and we found that they use executive directives to turn IG recommendations into binding action. It's something we raised with them. Chableng and I engaged them in a round table. We had quite a few agencies present. So there is a means to do that. But that obviously probably matches what we are saying here, that we need to ensure that a recommendation in itself is probably perhaps too early to turn something into a binding matter, that this process of executive directives are used, and we will find our own means to ensure there's proper consultation before a recommendation becomes binding and becomes remedial action. And then Chairperson Honorable Hendricks raising the issue of torture. So, one looks at the intelligence services, because the intelligence services is what is part of our mandate. And everything done by that intelligence service, whether it's of a human resource nature, because people collect intelligence, or financial nature, money funds intelligence operations. So it's all part of our purview. And, we make a reference to our earlier comments that Section 210 requires that the objects, powers, and functions, powers, must be regulated. And there are regulations at various levels. The legislation is there, and we made mention of the fact that there's a missing layer. There needs to be more executive directives managing and regulating key intelligence functions. At the lower level, we have operational directives and operating procedures. The operating directives are very important to determine, the manner in which the intelligence cycle is given expression to. And that is where the intelligence gathering methods are expressed. And in the methods that are prescribed must be compatible with the chapter on human rights in the Constitution. And the principles of proportionality are very important, that the least intrusive method must be used to gather information before a more intrusive method is used as a last resort as well. That torture is something that is not compatible with our Constitution. It's not compatible with the method of gathering intelligence in terms of our operational directives. So we've never been confronted with an intelligence gathering method that is in breach with the Constitution, as torture would be. So torture is not something that is allowed in our dispensation. We've not been confronted with that particular concern. So I hope that allays your concerns, Honourable Member. Chairperson, thank you very much, and I think I've dealt with the questions.
Honorable Hadebe.
No, Chair, it is not my intention to drag this matter. But I don't, it appears as if the IG seeks to suggest that consultation will ultimately lead to all the recommendations being accepted. And we know that that's not the case. Even after consultation, you might have instances where you differ. I'm asking this precisely on the basis that if you insert the part that it becomes an offense not to implement, yet there were clear dispute or instances where both parties could not agree, and you went ahead and continue with your recommendation, what then becomes the recourse in that instance? Because consultation does not automatically lead to consensus.
Chairperson, thank you. Chairperson, you know, seeing that the question has come back, I'm going to take one step back. In our work, I think the committee would appreciate this more than anybody else, that this practice of sharing information with the intelligence services and finding solutions is very important to the work that we do, because there are lots of shades of grey. And finding solutions means understanding different perspectives. In fact, we were quite fortunate, as I mentioned, we made 130 recommendations that were transmitted to the minister. I would say there were perhaps 2 or 3 recommendations that were not agreed upon, but the larger majority was agreed upon. It demonstrates our ability as the respective parties to find each other. In all fairness, you know, on the merit of the issues confronting us. But from a technical perspective, Honourable Debbie, what we're saying is that the optimal approach would be not to make recommendations binding, but to consult recommendations, and where they are agreed upon, they should then be considered to be remedial action, and those should be binding. So that is my response on the technical level. Honourable members, happy. Thank you. Thank you, sir. Thank you, Chair. Thank you, members.
Okay. Why didn't you simply say where they don't agree, they must bring it to the GILAB? It would have been simple. Okay. Then are we at that stage where okay. Well, as I was saying, isn't it the minister transmits to the GSCI? And if there's a dispute, then it means the GSCI will have to take a decision there, whether the minister is right or let the minister account on whatever. So I think that solves the problem. Maybe the GSCI has got the powers to tell the minister to do that. I'm not very sure. But it's one of those things. So this is the time for Honorable Kolabanat. And no speech, just thank them and let them go.
No, I'm not the one who makes the speeches, Mr. H. To the IG, thank you very much. Advocate Govender, inputs, extraordinary inputs, thank you very much. And especially to Mr. Mtuma, all the best for your retirement. You'll be greatly missed. It's been a pleasure working with you. I thank you, and thank you all for your input.
That was the best of them all. I haven't heard anybody saying there's a bit of a budget for a farewell function for Mr. Nchabeling. If there is, who is invited? And when is it going to be?
Your invitation's in the post.
Okay, we are waiting for the invitations then. Thank you very much. I think for this part the meeting is adjourned for 5 minutes, and the members will be here in the next 5 minutes to deal with the other items. Okay, can we? Exact. Okay, can we then, what do we have on the next thing? It's our minutes. How many do we have?
3 sets.
Starting from
2020.
20.
29, sure. 23rd.
Okay. Okay, the 23rd of November, one page for. Okay, there we are. Can we check the first page? The second page. The third page. On your mic.
I hereby move the adoption of the minutes, Chair.
Seconded, Chair.
The 29th, first page. The second page. The third page. The third page, bullet number 2 from the end, provide a regulatory framework for compliance monitoring. Do we need a comma there?
Is
Or
it not compliance, comma, monitoring?
that's what I was thinking. Fourth page. Anything on the fourth page? The fifth page. It's advert an abbreviation, or is it? I'm not very sure. It's a common word that is used professionally.
And in 6.1.
And in 6.1 also.
It's actually used in 6.2, which is interesting.
Any mover? Seconded by Honorable Luate. 30 minutes, the 5th of December, first page. Second page. The third page. On the second page.
No, on the third page.
Okay.
Third page, 2.5.1. The second bullet ends, but it has a semicolon, then goes straight on to the proposal is the deletion of members, etc. So I think it should there should be no semicolon, and it should be another paragraph. The proposal is X. It's like linking the proposal to bullet point 2, which is a bit odd.
So you're suggesting a
Just
third-
get rid of the semicolon after Chief Justice. So you've got the 2 individual bullet points, and then you move down to a new part saying the proposal is. And
Okay.
that I think would sort it. Thank you.
Page 4.
If I can just take you back one sec, I see that on the next page, on 4, each of the proposals has a bullet point. The proposal is, etc., the proposal is as follows. So perhaps on page 3 you should have a new poll with a bullet point, the proposal is, because that then matches what they've done on page 4.
Okay. Page 4, 2.5.3, the proposal to amend the section is line.
If you just take out section is,
It's in
to
line.
amend the line with section 5.1.a. So I think it means to amend the line. No, amend the section
Amend the section is in line with.
It's in line maybe.
to be in line with. How about to
In
amend
line.
the section to be in line or bring it into line with?
Is in line.
Is
Is in line. Column B is in line with section 5 subsection 1.
the proposal to amend the section is in line with section which direct, okay. Honorable Luate. Okay, I'm being advised that the proposal is in the act, because even on the proposal is as follows. On the 3rd bullet point, I still see an A there. Must appoint members. Can I be? Four.
Page 4, the 2 where we propose, someone proposed taking the A out.
I'm told the A it's in line.
It's a reference.
That's why even on the
Place some words.
that's correct.
Got it. Thank you for that.
Page 5. Page 5. Page 6. Honorable Luate and Honorable Kolaba. Are we then done?
Okay, Chair.
Okay. Okay. Can I be educated a bit here? As we do our minutes, do we need what? The media?
Doesn't matter. Yes, discuss in public.
So it's no. I was just thinking, or what if they put it? What if they put it in the public that changed A?
Surely they won't do.
Okay. We have got. Oh.
We are in a way cleaning up our documents before they even become public documents. That's why I'm saying I hear your point.
Yeah, that's what I was thinking. Or the A. Okay. No problems then. I understand these things are not on now. Okay. Then we have dealt with that. On the agenda, we have got the program. The program in front of us, Honorable Stebe.
Chair, thank you for the work that's been done on this program. I think it was some of the visitation was just shifted. I think it's a better outlay as it was, and I think we must stick with this one because that is the most sensible program that we can put forward. And the dates, we stick with it. I don't think we need to change on this program. Let's just go and do our job and get it done over. Thank you.
I think I wouldn't comment on the program because I see on the 23rd